Randy?
This is Randy Johnson. I'm chair of Seyfarth's government relations group here. Prior to this job, I was 20 years with the U.S. Chamber of Commerce and then 10 years on Capitol Hill as labor counsel of the House Labor Education Committee.
Hi, and I'm Clark Kerker. I'm Vice President of Government Relations here at the Illinois Chamber and formerly legal counsel at the Illinois State Senate.
A few other housekeeping matters before we get started. I'll be announcing a CLE code near the end of the presentation. You'll be sent an email after today's presentation so that you can apply for CLE if you'd like. So be sure to make note of that code. We also encourage you to enter questions through the Q&A feature of the webinar. Throughout the program, we're going to reserve some time at the end to try to get to as many of your questions as possible. And then lastly, we'll be doing a quick poll at the end of the presentation to gauge interest in participating in our BIPA legislative efforts. So we'll help you participate in that as well. And with that, we'll get started. So BIPA and COVID-19 in the same sentence. I'm sure everyone is thrilled to see that, but here we are. Hopefully this presentation today gives you an update on where we are with these cases, what we anticipate in the way of COVID-related BIPA litigation, provide some tips on how to implement COVID-19 technology while minimizing your BIPA risk, and then lastly, some information regarding meaningful steps you can take to try to get some change to this statute and stem the tide of these cases and hopefully reduce the exposure that these cases have been bringing to our clients. So we'll start with an overview of BIPA. We'll move on to talking about probably the main concern for everyone today, BIPA in the time of COVID-19. As we know, many of you are implementing new technology to try to address COVID-19 concerns. Then we'll talk about an update on the evolution of BIPA litigation, where we are in terms of the forum, state or federal court, go over the defenses that are being raised to these lawsuits and the success rate of those, at least thus far, as well as anticipated battlegrounds for these cases going forward. Then we'll talk about some considerations to keep in mind if you are planning on implementing compliance with BIPA. And then we'll turn to Randy and Clark, who are going to talk about proposed legislative fixes on some amendments that are currently pending and how you can get involved, as well as leave some time for questions.
Hi, everyone. So I just want to start with a little bit of background about the law. Some of you are probably familiar with it. It was enacted way back in 2008, but really has only gotten a lot of attention in the last few years when there's been a lot of litigation being filed. There's kind of a sparse legislative history included in the bill, but what is there suggests that it was really primarily a consumer-driven statute. It was motivated, and this is all included in the history, by the bankruptcy of a company called Pay by Touch. And that was a vendor who essentially, outsourced their services to various commercial outlets and retailers, which would use finger scanning technology and other sorts of scanning technology for payment purposes. And essentially, the company went bankrupt. The legislature, says that it was concerned about what was happening with all these consumers' info as a result of the bankruptcy, which motivated the enactment of BIPA. So according to BIPA, what it really does, and the thrust of it, is it regulates the collection, use, safeguarding, handling, storage, and retention and destruction of biometric identifiers and biometric information, which we'll talk about a little bit about in a bit. And like I said, because it's a 2008 law, but really it's only been litigated, or there's only been private rights of action and class actions being asserted in droves in the last few years. There's still kind of, it's working its way through the courts, and courts are still interpreting various sections as to what they mean, and we'll talk about kind of the developments in that area as we move along. So like I said, really in 2017, we saw just an explosion of class actions being filed under BIPA. And we have down here that more than 50 were filed in 2017 alone. And really, I think what motivated that was, As we'll talk about, there's significant penalties involved, and more importantly, there's an attorney's fees provision. So the plaintiff's bar, I think, realized that this technology was being used in an increasing amount of context, including the employment context for timekeeping, security, and so forth. And they just started filing cases, and they would find new clients in different contexts and, sign them up and essentially, fill out the same sort of complaint that they've been filing in other cases, and then they're off and running. As we say here, it's really, in Illinois, the plaintiff's bar is not discriminated against types of industries. We have seen some industries being targeted, I guess you'll say, a little bit more than others. The hospitality and service industries, manufacturing industries, healthcare industries, retail, airlines, you name it. Any company that uses this sort of technology is, a potential target for litigation. So who is covered? So BIPA defines private entity as individuals or corporations that are covered under the statute, and we have the definition right there. Any individual, partnership, corporation, LLC, association, or other group, however organized. It does include some specific carve-outs, though. For example, it exempts completely financial institutions and contractors, subcontractors, or agencies of a state agency or local government when working for that state agency or local government. It doesn't override certain other statutes, though. So, for example, it doesn't permit or prohibit the admission of biometrics in any action. It also is not to be interpreted to override various statutes which we have listed here, including the X-ray Retention Act, the Illinois Private Detective Private Alarm Private Security Act, and HIPAA. So what is a biometric identifier? So BIPA includes two definitions, and we'll talk about both. One is a biometric identifier, which is a retina scan or an iris scan, fingerprint, voice print, or scan of hand or face geometry. And then it goes on kind of confusingly to list a whole bunch of things which biometric identifiers do not include. And we've got the whole list here. I won't read them all for you, but I want to highlight a few because there has been some litigation on a couple of these exclusions, one of which being photographs. And we'll talk about it later on, but it excludes photographs, but there is a wrinkle where if there's a photograph that is then being transformed into a facial scan of some sort, there is some precedent to suggest that that might be biometric under the statute. And also another one I wanted to highlight was biological samples used for scientific testing or screening, which could apply potentially in the COVID context for some of the technologies that are being implemented. Okay, so importantly, not only do we have the biometric identifier definition, but we have this broader biometric information definition. It sort of, in our minds, acts as a bit of a catch-all, which essentially encompasses any information, regardless of how it is captured, converted, stored, or shared, based on an individual's biometric identifier used to identify an individual. Biometric information does not include information derived from items or procedures excluded under the definition of biometric identifiers. So essentially, because this is broadly written, it could potentially, it's still being resolved in the court, could potentially include, data points or something that's smaller than an actual fingerprint or a facial scan.
Now I'll talk about the requirements that BIPA has in place, primarily found in Section 15. So the first one is a written policy. And kind of consistent with what Tom was talking about earlier, there are certain tells throughout the statute that show that the legislature at the time was very focused on consumers as compared to employees. So a few things associated with this written policy requirement tell us that. So Section 15A of BIPA, which comes into play in some of the case law that's been developing, which we'll get to in a minute, around Article 3 and whether these cases should be heard in federal court. It requires that a private entity in possession of biometric identifiers or biometric information must develop a written policy that contains certain features. So a retention schedule guidelines for permanently destroying the biometric information, and it contains a time period in here that is required as well. So the information must be permanently destroyed either when the initial purpose for collecting or obtaining such identifiers or information has been satisfied, or within 3 years of the individual's last interaction with the private entity, whichever occurs first. It also requires that the policy be made available to the public, and this is one of the tells I was talking about, because in the employment context, it doesn't make much sense from my perspective for a retention policy regarding biometric information to be widely disseminated, particularly in this day and age where nearly every company is dealing with computer and hacking and other data privacy issues. It seems that the policy, from our perspective, should be made available to those who have reason to know. And that's something that Clark and Randy will be talking about later in terms of one of the pieces of the proposed amendments to BIPA. But in any event, this suggests, again, that the focus of BIPA was consumers as compared to employers and employees. The last component is that the private entity must comply with this absent some court order or some other court requirement. 15B is the requirements that must be met before the biometric information is collected. And this has turned out to be important in terms of the Rosenbach decision that the Illinois Supreme Court heard in taking a look at when an injury under the statute is sustained. So Section 15B of BIPA requires that no private entity may collect, capture, purchase, receive, or otherwise obtain. So essentially any means of obtaining a person or customer's biometric information unless it first, and that's the key part there, before the collection begins, informs the subject or that person's legally authorized representative in writing that biometric information is being collected, informs them in writing of the purpose and length of term for which the biometric information is being collected, stored, and used, and then lastly, receives a written release executed by the person or that person's legal representative. So these are probably where the focus of a lot of the litigation has been to date. Written release then in turn is defined, again, there's a number of ambiguities in the statute. Written release, I would say, is one of them. It is defined as informed written consent, or in the context of employment, a release executed by an employee as a condition of employment. If you take this literally, it means an employee would have to be terminated if they refuse to agree to provide their biometric information. And in general, I think when we've been working with clients to get in compliance, we've not advised them to do that, but it's just one oddity in the statute. I think the intention was likely to try to make the consent have some teeth, but it's just sort of oddly worded, and is another thing that we proposed be cleaned up as part of the BIPA amendments that are on the table. Section 15C provides that no private entity can profit from a person's or customer's biometric information. Again, kind of focusing on consumer use, that they do not want the sale of biometric information. And then turning to 15D, no private entity in possession of biometric information may disseminate that further unless there is consent. The disclosure completes a financial transaction. The disclosure is required by state or federal law, or it's required pursuant to a valid warrant or subpoena. These allegations regarding dissemination have been a focal point of the litigation around Article 3, as often in the sort of cookie cutter complaints that we've seen in this area, there are allegations of dissemination. And it's really part of the understanding the relationship between the company and a vendor to try to understand whether the data has in fact actually ever been provided out to the vendor, whether it's stored locally, but this is something that's gotten quite a bit of scrutiny in the litigation thus far as well. And then Section 15E provides the care with which the data must be maintained. So it relies upon a legal standard using the reasonable standard of care within your industry. And it wants you to store the information in as or more protective manner than you store other confidential and sensitive information. So, for example, if you're a healthcare provider, you're going to be held to the standard that you store other health information. Other confidential and sensitive information is defined in the statute as well, covering things like Social Security numbers and birth dates and that type of information.
Okay, so Section 20 of BIPA is probably the star of the show, why we're all here, and really what makes it unique is that it provides a private right of action for individuals to sue, unlike a couple other biometric privacy laws that are currently on the books in other states like Washington and Texas, where only the Attorney General can move to enforce those laws. So like we said earlier, it's got a prevailing attorney's fees provision, and it also has statutory penalties, which it defines as $1,000 or actual damages, whichever is greater for negligent violations, $5,000 or actual damages, whichever is greater for intentional or reckless violations. Again, there's a little bit of ambiguity as to what's negligent, what's a negligent violation, what's an intentional violation, and also the actual damages. I mean, in most cases that we're seeing in litigation, there really hasn't been any actual damage. There hasn't been any actual identity theft or breach. So really what we're talking about here is the statutory penalties and the ability for individuals to bring class action lawsuits against their employers or companies as a result of this is really driving a lot of focus on the statute.
Now we'll talk about BIPA and BIPA concerns that have been coming up for many of our clients as they try to deal with the COVID-19 pandemic. So first, we're getting sort of mixed messages in terms of trying to implement some of this technology. I would say today we're focused exclusively on the BIPA components. There are, as I'm sure most of you are aware, a whole host of other statutes and privacy and health issues that should be considered in implementing any new technology to try to get your arms around the COVID-19 virus. So first, what we're seeing is we've got some agency guidance that expressly authorizes employers to measure employee temperatures. So we have that coming from the CDC. We have that coming from the EEOC, which has issued guidance recognizing that employers may continue taking temperatures of all those entering the workplace. And then we're seeing really just, nearly every state that can issue some guidelines about returning to work has issued them. Many of those guidelines allow or in some cases mandate temperature taking. So we know that all of you have been doing your best to put that patchwork of laws into practice and also try to protect your employees and your customers. And that's where we're getting all of the inquiries about the new technology. The technology we're seeing, at least at this point, is sort of taking the form of three different buckets, sort of from the smaller, more rudimentary, no contact temperature taking devices, which many of us were already aware of, which is a scanner that's placed just a few inches from an individual's forehead. You push a button and you find out the temperature. There's no retention of that information, which is important if you think about the definitions of biometric information and biometric identifier that Tom was talking about. And we're seeing this used more in a mom and pop kind of setting, or at least to get started in terms of compliance. Now we're also seeing, moving to the second category, this is a long-term problem, and our clients are trying to find long-term ways of dealing with the temperature-taking requirements. So we're also seeing the implementation of scanning devices, where a person walks through a device that has the technology to conduct a thermal scan and do a readout of the temperature. What we are seeing repeatedly with this technology is that it was created to be coupled with facial recognition technology as well. So on multiple occasions, we've received inquiries from our clients that indicate that that feature is being turned off of the technology, which is important. I think we've talked about facial recognition. You're really getting into one of the categories that BIPA has outlined it is intended to govern. And the closer you get to those very clear set of categories, the more likely you are incurring some BIPA liability. And then the third category we're seeing are wearables, watches. There's even some apps and things like that that I've been seeing thrown around in terms of trying to collect information. But what to be mindful of with this category is that it can be incidentally collecting other biometric information or information that somebody might argue is biometric information. So in general, you should be trying to collect the bare minimum of the data that you need to do the job. In terms of the facial recognition technology being shut off, and Tom will get into some best practices in terms of trying to implement this new technology and try to minimize BIPA liability. So whether BIPA applies to this technology depends primarily on what's being collected. And also, in getting to what Tom will be talking about, almost the perception of what's being collected. We're in a situation where plaintiffs' counsel are suing now and asking questions later. And so if there is a perception that a certain technology is being collected, that will lend itself to a higher likelihood of a lawsuit. So as I noted, if the technology is in fact collecting this information listed on the slide here, retina or iris scan, fingerprint, voice print, scan of hand or face geometry, you're really getting into the core pieces of BIPA and a higher level of potential BIPA exposure. And there are certain provisions in BIPA that there's nothing in BIPA, I guess I would say, that squarely exempts the type of temperature taking that employers and companies are trying to do in order to comply with this federal and state guidance and regulations. There's a few provisions under biometric identifier, as Tom was talking about, which is a very confusing definition, and frankly, the judges have grappled with how to interpret it. But there's a few pieces under there that are supposedly excluded: biological materials regulated under GINA, information captured from a patient in a healthcare setting, or information collected, used, or stored for healthcare treatment. And also there's a section that says other images or films of the human anatomy used to diagnose, prognose, or treat an illness or other medical condition. So certainly these are areas in which we would intend to argue that some exemptions would apply to well-meaning and good faith employers and clients trying to comply with all this federal and state guidance. But there's certainly nothing that is clear at this point that would exempt, certainly nothing specified, sort of an emergency situation, which we are in at this point. But these are all pieces of the statute which are open to interpretation, which only increases the liability associated with BIPA.
If to echo Ada's point, I mean, really what we are advising our clients to do is just really exercise caution in this area. If you want to put in this sort of technology, particularly if there's a technology that has something that might be capturing facial scans, or you think might be capturing facial scans. So really what I want to talk about now is if that's the case, what do you do? And like Ada said, unfortunately, there's not a clear provision in BIPA that says this is excluded for temperature taking or, an emergency situation. So what do? The first thing you do, I think, is you really got to dig into the nature of the technology. So what's being collected? I would have a list of questions, or you can have your outside counsel prepare them for you, but really do your due diligence with the vendor as to what is it doing, what features does it have. If it has a facial scan or a facial recognition component, can you turn it off? If it's turned off, what does that mean? Is it still collecting anything? Is it possible that it's still, storing some sort of data? If so, that could lead to some potential exposure. And like Ada said too, anything that looks facial recognition in nature right now is really something that consumers and employees really, it's on their radar. It's something that's been in the news. It's something that they know about. And, with that said, it's something that they could very easily, challenge and bring a case for, and you can end up, at summary judgment trying to defend the technology and saying that it doesn't do what they're saying it does, which could be an expensive process. So to that end, also just, research your vendor, what protections does it have in place, what is the vendor saying that what data is stored or what features it has, where does the data go. All these flows are very important to determine whether or not, the technology ultimately might implicate the statute. Importantly, I think that this is something that, you should probably talk to outside counsel about and get them involved, and even have those conversations for you if need be. Another thing too is that we see, I would also recommend, and I do recommend to clients that they, talk to their vendor about contractual issues, potential indemnification, clear responsibility for the data, who's going to be responsible for what, and so forth. Finally, insurance coverage, that's big. When these lawsuits were first being filed a few years ago, there wasn't a whole lot of coverage, at least to my understanding. There's more so now as these cases are kind of on the radar. So, maybe look into if you're going to implement one of these technologies, what sort of coverage would apply, and possibly seeking out such a coverage in case there is some sort of lawsuit filed under BIPA. So just to reiterate, in light of the very litigious nature of what's going on, caution is really the goal here. I think that there were already a lot of lawsuits being filed, even before COVID hit, and now, this new technology being thrown into the mix has potential to even increase that amount. You might see, enterprising plaintiffs' attorneys, focus on these technologies. And like I mentioned before, the nature of the technology itself and what it's capturing and collecting and storing is really something that can't be decided on the pleading. So if you think, this is something that, I'm pretty sure that this is not collecting facial scans. Well, if they, plead that and, the court has to accept that allegation as true, then you might have to get into discovery, maybe even expert testimony, and try to prevail on that issue at summary judgment, which we all know is particularly expensive. So, our overall recommendation, like we say here, is to always comply if possible. If you have any questions about what the technology is doing, maybe it implicates facial scans, go ahead and get consent forms, have a policy, and do the things that you need to do to protect yourself against a lawsuit. So we're going to back up a little bit and talk about kind of how these cases started. Like I said, a few years ago was really when we saw the first filings, but it really reached a watershed moment back in January 2019, where there was a case that went up to the Illinois Supreme Court, and it was called Rosenbach versus Six Flags. Essentially, it was a mother who sued Six Flags on behalf of her daughter, who gave her finger scan to Six Flags as part of the season pass. Six Flags said, hey, the statute says you need to be an aggrieved individual in order to recover damages or seek penalties. The Supreme Court did not buy that. They essentially said that there does not need to be any allegation of actual injury or adverse effect beyond just a mere technical violation of the statute. What does that mean practically? That means essentially that a technical violation alone is enough for individuals to move forward on this case, essentially almost interpreting it as a strict liability type statute. As expected, after the Rosenbach ruling, we saw just an avalanche of cases being filed once plaintiffs and the plaintiffs' bar realized that they don't need to have any injury, essentially, to move forward on these cases. Anybody who used the scanner or scanners at any companies essentially, had a private right of action to move forward.
Okay, now we'll talk about the venues within which these cases are being litigated. And that has been a battle that's been going on pretty extensively. And Tom and I have litigated one of these cases extensively up to the Seventh Circuit in a case titled Johnson versus United Airlines that was consolidated with the Miller versus Southwest case. So this started with Patel versus Facebook. And I think a couple of points about this case. We're talking about an Illinois statute, but that doesn't mean that you won't end up facing these cases in other jurisdictions that may have reputations for being less friendly to defendants. And I would say the Facebook case is potentially one of those. So this lawsuit was originally brought in federal court. It alleged that Facebook's facial recognition software, with which many of you are probably familiar, sort of this tag suggestion software, violated BIPA. And Facebook argued that there was no Article III injury that would allow a federal court to sustain federal jurisdiction. It was sustained at the lower court level, and then the Ninth Circuit reversed the district court, finding that there was an Article III injury, and also finding that there were not issues that would preclude class certification. So as you can imagine, this is a massive class. The Facebook petitioned the Supreme Court for review, and the Supreme Court did not take the case. Shortly after that happened, the case settled for $550 million. And the estimated exposure for that case was a whopping $34 billion. I will say what's just come out is in connection with the motion for preliminary approval of that class, that the district court judge commented that he wasn't sure about the amount of recovery each class member was going to receive as compared to the exposure. So $550 million, that's an eye-popping number, and the judge, it remains to be seen whether the judge will be satisfied with that. Hopefully he is, and it is unusual for class certification to not be entered in these types of cases, but I think it was worth noting. Our expectation is this giant settlement number is only going to increase focus of the plaintiff's bar on bringing these types of lawsuits when you start to see numbers like this. And so we are starting to see more activity in the consumer sphere. So we're seeing the TikToks of the world and other retailers who use face recognition software being tagged in these lawsuits as well. So the case that I talked about before, the Miller versus Southwest case, this is a case where we litigated this Article III injury, and the shoe was on the other foot. So we removed the case from Cook County to the Northern District of Illinois Federal Court, and plaintiffs there argued that they did not state an Article III injury, seeking to have the case remanded. Initially, we prevailed, and the district court judge reversed herself. We sought a special appeal up to the Seventh Circuit that was granted, and the Seventh Circuit reversed, finding that there was an Article III injury. But we were in the sort of peculiar position, which many defendants are in these cases, of saying, look, you're alleging all of these violations under BIPA. How can you argue in the same breath that there's not a sufficient Article III injury for the federal court to exercise jurisdiction? So we're continuing to see litigation in this area, including in the next case that we wanted to feature here, Bryant versus Compass Group. There's been some very recent developments. You can see here early May in this case, in which the Seventh Circuit here took a look at the various claims that were being alleged and held squarely that BIPA Section 15B claims, that is, claims regarding what must be done before you collect the biometric information, that there was an Article III injury sufficient for federal court jurisdiction there, but that with respect to the facts at issue in that case, that for claims brought by the plaintiff under Section 15A, that is that section I was talking about, developing a publicly available retention policy, that those did not state an Article III injury. So there's been a petition for rehearing en banc that's been filed in that case by Compass Group to try to have the entire Seventh Circuit take a look at that ruling. If it's allowed to stand, there is the potential for these cases to have to proceed in two different forums. So the 15A cases in state court and the 15B and potentially other Section 15 claims in federal court, which I'm not sure that's a desirable outcome for anyone, and it certainly circumvents the basis of CAFA jurisdiction, which is to take some of these large class actions and put them into a federal court for jurisdiction and oversight. So we'll have to see how this plays out and whether this holding will be upheld whether the petition for rehearing en banc will be granted. There could be further activity involving the Supreme Court too, depending on how this goes. And then certainly it also remains to be seen whether it will be confined to the facts presented in that case. But right now there's still continuing to be confusion in this area. There's a few things that allow defendants a little bit more of a foothold in federal court, but remains an ambiguous area in these cases.
So we're going to talk a little bit about some defenses that employers and companies are pursuing. It might sound based on, you know, all the cases being filed and the Rosenbach versus Six Flags decision that this is a strict liability statute, and some courts have kind of interpreted that way, but there are some significant areas and victories that defendants have kind of staked a foothold in and gained some traction, one of which being in the arbitration context, and that's particularly prevalent in the employment arena, where a lot of employers do have arbitration agreements, or they make employees sign arbitration agreements as part of the onboarding process. So the U.S. Supreme Court's decision in Lewis versus Epic Systems, which essentially upheld class action waivers in arbitration agreements, has become an effective tool in defending BIPA class actions. You know, if you have a named plaintiff that has signed a arbitration agreement with a class action waiver, courts are not hesitant to go ahead and say that that needs to be enforced as written, and really the only recourse or the only venue that plaintiff can pursue their claim is in the arbitration on an individual basis. So that's been a really effective tool to limit exposure and essentially moot a class action to the extent that that individual that signed an arbitration agreement is trying to represent other individuals in the case. So we just wanted to highlight a couple of specific arbitration decisions, one of which was very recent, and that was on May 15th. It was a BIPA class action against Shutterfly, and essentially a federal district court in the Northern District of Illinois granted a motion to compel arbitration. Essentially, there was a terms and conditions. There was a unilateral modification of the agreement without notice, plaintiff alleged. And essentially the notice said that, you know, by continuing to use the website, that she was agreeing to these new terms. And notably, this notice came 3 months after the lawsuit was filed, telling them that the terms and conditions had been updated. And it, like I said, if they didn't close out their accounts by a specific date, they accepted the terms. And the court actually, you know, bought that argument, and they said that plaintiff was bound to arbitrate her claims according to the terms of service. So really, when this decision came out, I think it's an important ruling because it provides some kind of creative angles for employers and companies to kind of implement these arbitration agreements in terms and conditions or in other onboarding materials to try to extinguish a class action and send it into arbitration.
And this is Ada. I would just chime in as well that to the extent you have not looked at your terms and conditions, now is another opportune time to do that. This is a reminder to kind of take a look at those, and if you've been holding off on an arbitration provision with respect to employment claims, perhaps you could consider, if you have a consumer-facing relationship, taking a look at your terms and conditions, because we do expect, you know, these cases to continue unabated, and these have been effective defenses.
And great point, Ada, and that kind of leads us into the next case we're going to talk about, which was a decision which came out the other way against Vimeo, essentially where there was a terms and conditions and included an arbitration provision, but the terms and conditions and that arbitration agreement contained a provision that exempted claims related to arising from allegations of theft, piracy, invasion of privacy, or unauthorized use. And the court essentially said that a BIPA claim is a privacy claim in a lot of regards. You know, it's mentioned in the statute. There's a lot of references to privacy concerns, and for that reason, they found that that exclusion applied. So even if you have an arbitration agreement, like Ada said, that's not necessarily a slam dunk winner. You got to make sure that a BIPA claim is, you know, either expressly written into your arbitration agreement, or alternatively making sure that it's not included in some sort of exception.
So another area of defenses to these class actions that has been effective is preemption arguments around collective bargaining statutes like the Railway Labor Act and the Labor Management Relations Act. So one of the first cases to address this issue was a case Tom and I, as I noted, handled, Johnson versus United Airlines. And in this one, the Seventh Circuit held that the state law claims were in fact preempted by the Railway Labor Act and dismissed the cause of action to be decided according to the arbitration provisions of the collective bargaining agreement. And the key piece was that the collective bargaining agreement contained a management rights provision that gave leeway to the employer to have certain terms and conditions and even equipment associated with employment. And that proved key, I think, in both of these cases, both for Southwest and United. And this argument, once it gained some traction under the Railway Labor Act, has, as we've seen, been successful now in any unionized workforce setting, particularly, I mean, either if you have a named plaintiff who is a party through a union to a collective bargaining agreement, that has been an effective defense. And it also is something that could be leveraged in working to try to defeat class certification, pointing out that you have differences between class members, as many as you can find. Certainly this would be one of them. If you have a workforce that's partially collectively bargained and partially not, that would be another feature to focus on in defeating class certification. So we, as I said, these have gained some traction in the LMRA context, and we have a couple cases here on slide 37 that have granted motions to dismiss, finding these claims completely preempted in those contexts where you need to rely upon the collective bargaining agreement to really interpret the rights between the parties. And what this means is not that the BIPA claim lives another day and ends up in arbitration. It's typically the remedies just simply aren't available. The state court claims being, or the state claims being brought under BIPA are completely preempted by these federal statutes. So this has been one of the areas of success in terms of these cases, defeating them completely. But overall, I would say the theme is that judges in the initial stages have been really reluctant to decide any issues that could implicate fact issues. And that's kind of what we're seeing with the next defense on the next slide here regarding preemption arguments by the Illinois Workers' Compensation Act. So employers have also been arguing that the Illinois Workers' Compensation Act completely preempts these claims. These are claims often arising in the context of the employer-employee relationship. And so far, courts have concluded that BIPA claims do not allege an emotional or physical injury that's covered by the IWCA. There's a ruling here, though, that interlocutory review has been certified and is pending in the first district. So we'll have to see how those play out. And we have a couple more cases here as well in terms of preemption arguments that are being made for these claims.
So we wanted to highlight a few key specific areas where we think that the litigation might be heading, particularly on issues where there's a little bit of ambiguity in the statute. The first of which is the statute of limitations. Unhelpfully, there is no statute of limitations in BIPA, unlike other statutes where there's a private right of action, which is unfortunate. So what we've seen plaintiffs arguing for a 5-year catch-all limitations period, and there have been a couple courts that have applied the 5-year limitation period. Defendants are arguing in the alternative for a 1-year privacy-based limitations period, and alternatively sometimes also arguing for a 2-year statute of limitations period where a plaintiff is seeking statutory penalties. There haven't been any federal court decisions on this. Like I said, there have been a few decisions applying the 5-year limitations period. The issue's up at the appellate court in Illinois, and we list those cases there. You know, it could be in light of the COVID pandemic and kind of the shutdown of the courts. It could be, you know, into early next year until we get some settled law as to the appropriate limitations period, at least at the appellate district level. It could always be subject to review by the Illinois Supreme Court, But really, I mean, this is a very important issue because, you know, if there's a shorter limitations period, especially if you have a bigger potential putative class and a lot of employees or a lot of individuals in it, if you can get a ruling that a 1-year statute of limitations period or a 2-year statute of limitations period applies, that could really greatly reduce the potential exposure of these class actions. Then another area that we're keeping an eye on, and I feel like we've made this point quite a bit today, is whether or not the technology captures biometrics. You know, there's been a couple cases at least denying such arguments at the pleading stage, and we've listed them there. And that's largely due to the broader definition of biometric information that we talked about. So really what we're expecting to see is once these cases move into discovery and potentially the summary judgment stage, is defendants putting on arguments, perhaps expert testimony to try to demonstrate that their technology or what the technology is doing is not collecting biometrics. Again, I think that that's you know, going to be an expensive and very fact-intensive exercise. So to the extent, like we talked about, that there's any ambiguity about whether or not the technology is doing that, or the technology that you're thinking about implementing is doing it, really the safest course of action would be go ahead and either get it shut off and confirm that, you know, it's not doing that at all, or alternatively, just go ahead and take the compliance measures that the statute requires.
Okay, another issue where we expect continued litigation, and again, what we're seeing is these cases are relatively new. Statute's been around since 2008, but only recently been making its way through our courts. And so all of the ambiguities in the statute, and Randy and Clark are going to talk more about some efforts to try to get clarity with this statute, but all of the ambiguities are lending themselves to judges deciding at the early stages in motions to dismiss that they simply don't have enough information to dismiss the cases. And then, of course, you're stuck embarking on a fairly extensive discovery period in these cases, including likely to include expert discovery. So one of the other areas that has been litigated and that I think will continue to be litigated is the concept of an extraterritorial application of BIPA. So one example of this is in the Facebook case. Facebook argued that its servers, which was the equipment actually doing the collecting of the face scans at issue in the case, were not located in Illinois. And so the argument was that this was an impermissible attempt to apply an Illinois statute outside of Illinois state limits. The judge in the Facebook case found that there was a sufficient nexus between Illinois residents and Illinois state law, and so Facebook was not successful in this argument. But these are the types of arguments that defendants will be focusing on still in the early stages of the case. And we've also heard of some instances where if there are very limited contacts with the state, that there may be some personal jurisdiction arguments to be made as well. But in general, we expect this to be litigated early in the cases and then potentially again at summary judgment stage if the judge doesn't feel comfortable pulling the trigger on dismissing a case early in the case. It's also another opportunity, again, to sort of slice and dice the proposed class in terms of who was involved with the technology where, and whether the individual fact inquiries that will need to be made should defeat class certification. And as these cases continue to work their way through the system, we expect more litigation around the damages and penalties provisions of BIPA, which contain their own ambiguities as well. As Tom has noted, we have yet to have a plaintiff who has demonstrated identity theft, someone recreating their biometric information without their permission in these cases, which is remarkable. But the statutory penalties that are required under the statute make these very high exposure cases. And then there's ambiguities in the statute regarding how often each of these statutory penalties accrues. Is it each time? So in the case of finger scan timekeeping, is it each time an employee swipes in and out, multiple times a day? And we certainly have the plaintiff's bar arguing, as you would expect, for the most aggressive position around that yes, each time there is a scan, that a penalty accrues, and then you multiply that times the longest statute of limitations, given that we don't have one of those in the statute either, you can see how these damages start to pile up. And there's also some debates in terms of negligent versus willful violations. There have been some early successes where the courts have said, I'm not seeing anything in this complaint that shows me it was a willful violation, and they've granted some motions to strike some of those allegations. Again, some of the strategy in these cases, because many of our clients were sort of caught flat-footed when these cases started coming out. It simply was a case that, or was a statute focused on the consumer relationship, and employers, I think, unfortunately had to learn sort of the hard way that these cases are being applied fairly broadly in the employment context. So some of the efforts in these cases is to really try to prune the case down as much as possible to reduce the exposure as early in the case as possible. So we expect to continue to see litigation around what constitutes a negligent versus willful violation. And as I've noted, in the context of class certification, those battles are beginning as well for the cases that have gotten past the early motion practice. And there will be a number of individualized inquiries required in terms of trying to establish who used the technology when, what was collected when. There's also lots of questions around consent early in the litigation of these cases. For example, there was one judge that in a case involving a video gaming situation where if you wanted to participate, you would undergo a lengthy face scan. The judge there noted that by participating in that was a form of consent. So I think the more obvious the scan, there's also going to be some debates over how much that consent plays a role, or if you have differing class members arguing differing levels of consent. All of those types of individualized inquiries are going to play a role in how big these classes are if they end up being certified. And then with respect to settlement, we are seeing a number of these settling. And again, going back to the Facebook case we've been talking about, just when you add up the penalties in the way that the plaintiff's bar has been able to do, given the ambiguities in the statute, we're talking about massive exposure in some of these cases. And so we are seeing frequent settlements of these cases. They are very fact specific, so it depends a lot on the obviousness of the collection, how long it's been in place, the number of employees or consumers that are impacted, whether there was partial BIPA compliance or not. So there's a whole host of factors, but we expect settlements to continue as long as these statutory penalties continue to be viable and not hindered by the rulings, and that's kind of what we're seeing so far. So we expect these settlements to continue in these cases, both because of the exposure and because of the cost of defense.
So we want to talk a little bit about compliance. Compliance is king here, really, in light of everything going on in the litigation landscape. It sounds like it should be a very simple exercise, right? I mean, the statute requires consent, it requires a public policy, but there are a lot of considerations that, you might not be thinking of right away. For example, a written release, do you make it mandatory? Do you make it optional? That's something that you got to think about. In Illinois, arguably you can do that because it defines release as a condition of employment. But if you're implementing this technology nationwide, making it mandatory could provide other, or cause other issues. For example, let's say there's an objection by an employee who doesn't want to use it because it's for religious reasons. And there has been a case on that where an individual wanted to opt out and the employer said, no, you have to do this. and he went ahead and filed a discrimination lawsuit and went up to the appellate court. I think it was the Fourth Circuit, and actually prevailed there. So it's really kind of a state-specific inquiry. Another issue that we talk to our clients about is, do you implement compliance in just Illinois, or do you do it nationwide? Do you pick certain states? There's a lot of different aspects that you have to consider. Another one is, how do you post your policy? How do you make it publicly available? Do you put it near the timekeeping system? Do you put it in a handbook? Do you incorporate it in part of your other privacy policy on a website? There's all sorts of different options for clients to think about, and that also requires some thought, because I think that what's going to happen is now plaintiffs are going to say, yeah, great, you have X, Y, Z, but they're going to try to kind of nitpick little issues with them, retention, destruction, things like that, and that could kind of be where we see additional litigation moving forward.
Thanks, Tom. And now I'm going to go ahead and read the CLE code, which is SS, as in Seyfarth Shaw, 4479. That's SS 4479. And now I'm going to turn it over to Randy and Clark to talk about some of the proposed legislative fixes.
Yeah, thanks, Ada and Tom, and hopefully now that you got the CLE code doesn't mean you've hung up, because we're about to enter into a different area. I'm going to shift the discussion here to talk about possible legislative amendments to BIPA and why these aren't a pipe dream. During my years on Capitol Hill and at the U.S. Chamber, working on labor legislation and writing a few laws myself, I've seen a lot of poorly drafted legislation with unforeseen consequences, and usually the business community, let's face it, just has to suck it up and litigate these problems and hope for the best in court. But occasionally there are those rare times when there are openings for improvements for legislative fixes, and I think really we have this opportunity here with BIPA, and not just to ease compliance for the business community. That's not what it's all about either, but really because there are many parts of this law that reflect it was extremely poorly drafted, and I think we've heard examples of that already, leaving it open to the plaintiff's bar to take it in directions I would bet the Illinois legislature back in 2008 or 2007 never even thought it would go. And while sometimes we on the management side overuse the phrase, quote, this is truly a gold mine for the plaintiff's bar, unquote, I think that truly is the case here, with very little meaningful protections for employees, or at least at costs that are not reasonable in any common sense of that word. So it's not a pipe dream, the kind of things we're going to be talking about here. And in any event, to explore where we are in Springfield and what are the chances of improvements. And I want to emphasize this. Unfortunately, we've already seen several proposed bills introduced. We're lucky to have with us today a veteran of the inside workings of the Illinois legislature and a senior official with the Illinois Chamber, Clark Kratcher. And parenthetically, let me note before I introduce Clark that I've worked with the Illinois Chamber over the years many times on many issues, and they've always been a go-to organization that gets things done. Clark serves as Vice President of Government Affairs. He's Executive Director of Technology and Infrastructure. Clark comes to the Illinois Chamber from the Senate Republican staff, where he worked as the Senate Floor Director and Legal Counsel, where he was responsible for analyzing and providing recommendations on thousands of pieces of legislation. And prior to the Senate, Clark served as a Chief Administrative Officer at the Illinois Department of Innovation and Technology. So Clark, thanks for joining us today. We've had many discussions about this issue, and we appreciate you making the time on your calendar to tell us where we are.
Well, thanks for having me, Randy. There are several pending legislative amendments in the Illinois General Assembly. In fact, there were 6 introduced. The Chamber had her hand in 5 of the bills, and then one was introduced by the Senate Majority Leader on his own, and I'll get to why that was a happy outcome for us. So the first bill I want to talk about was introduced by Minority Leader Jim Durkin, who's an attorney out of Western Springs, and Senator Jason Berkman, who's an attorney in the Champaign area. That's Senate Bill 3593. I like to call this the moderate reform bill, and I don't want to sell it short, but you'll see why I say that when compared to the more pro-employer form. And so this allows employers 30 days to cure any reported violations. It removes the automatic statutory penalties, which requires the plaintiff to show that she was actually damaged by the alleged collection or dissemination of biometric information. This is important because, like Tom and Ada pointed out in their presentation, nobody's been able to successfully do this to date. And out of hundreds of cases, that's fairly remarkable. I've been involved in a lot of legal reform issues, both in the State House and now with the Chamber. And in other areas, there's usually pretty significant damages. And the plaintiff's bar is able to bring very sympathetic witnesses to come testify. Well, that doesn't exist here. And that's novel, and that's a big advantage that we have as we seek reform. So the bill, going back to the bill, it also cleans up perplexing ambiguities in the statute that could be required to lead to employee termination. It ensures that sensitive policies governing biometric information are shared only with the parties who have a reason to know, so the employees and the company and the vendors. This is important as we are learning more and more that cybersecurity is a major issue for corporations, and that placing these sensitive policies out on the website for anyone to view just invites trouble. And then lastly, it makes clear that collectively bargained resolutions are issues that should be honored. So the same two sponsors, Minority Leader Durkin and Senator Barackman, also introduced House Bill 5375 and Senate Bill 3591. This was the most employer-friendly of the introduced legislation. And I say that because it completely eliminated the private right to action. And that doesn't mean you don't have to comply with biometric protection, but that means enforcement's with the Department of Labor instead of with the plaintiff's bar. And then also anything must be acted on within 1 year, so clear up that statute of limitations problem that we're currently dealing with. It also cleans up whether or not you're required to terminate employees that don't want to abide by biometric information usage. It makes sure that the cybersecurity issues are remedied, and that it also respects the collectively bargained resolutions. And then the fifth bill introduced by the Chamber was only done in the Senate, and that's because it was a last-minute drafting thing as the House deadline had already passed. But it provides that a prevailing party in a BIPA suit may recover $1,000 or actual damage. And once again, we've never seen any actual damages. So $1,000 against a private entity that violates the act. The $1,000 would apply to each unique identifier. So in this case, it'd be $1,000 for your face, maybe a separate $1,000 for your thumb if it was scanned, but not for every additional scan. It did not have some of those other very important technical fixes, and there are strategic reason for that, in that things tend to move in the big committees in late May over several hours, where 50 bills may be considered. And so the intent here was to come up and say this bill simply corrects the damages issue, and then we come back several months or a year later and make the technical fixes. And that is a time-honored Springfield strategy. And then the last bill was introduced by the Senate Majority Leader, Senator Cunningham, and it comes from, he had an assisted living facility in his district that was sued for BIPA. They end up settling for $2 million, and he was outraged about that. And so he put forward his own bill, which we were happy about because it's showing momentum and that people are understanding that this is a real problem and we're not just screaming into the wind here. He intends for this to be a starting point, and I hope that he will be a sponsor for future legislative amendments that we have coming down the pipe.
Yeah, and Clark, I think it's important to know here, thank you, that these are on you hinted at this, but these have been, some of these have been introduced on a bipartisan basis, and so there's interest on both the R&D side to move some fixes to BIPA. Those of us who have been in legislative efforts, and Clark jump in, but this isn't going to be an easy lift, but the payoff at the end is huge. 2 or 3 improvements in this legislation can save tens of thousands of fees down the road in litigation. And so nothing's guaranteed at the end, but if we put our shoulder to the wheel and put a little effort into this, we think we can get some done. And this slide here, it just talks about some of the things you as a business leader or owner could do to help us move some of these amendments. I think they're self-explanatory, but they don't take a lot of time on your part, but they do take a little effort. Contact your state representative and advocate for prioritizing passage of amendments to BIPA, and we can help shape sort of your message as to which of these we ought to focus on and which are reasonable. Author a short op-ed in a local paper online explaining the problems you've had under the legislation, either in compliance or how you've been beat up by plaintiffs, even in a way that hasn't really helped your employees. And you're a businessman or a woman, and you're just trying to get a product made, and yet you've got to pay these huge, albeit reasonable if they're from Seyfarth, legal bills. And it's money that could be spent in other ways. And emphasize, and I've used this on Capitol Hill many times, that this is just one law that you have to comply with as a business person. I mean, it's an incredible matrix of not just employment laws, but environmental, et cetera. And you want to comply, you want to meet, of course, the requirements of the law, and all you want to do is make sure that the law is reasonable and not unduly punitive. And then, if possible, go to Springfield and visit your representatives. There's nothing better than a personal visit. And we can help prepare you to say the right things if those visits get set up, or maybe you make a phone call and you need a script. We can help on that. And then, of course, partner with Clark and the Illinois Chamber, who really have the inside track here where the rubber meets the road, as to how to, what are the pinpricks to hit at the right time as things start to move.
And I can't underscore how important this is, because I think we get a lot of the same voices. It's sort of the same choir always singing the same songs in the General Assembly, right, on both sides. And so fresh voices tend to get the most attention. And this is something that's affected every elected representative's districts. And your story could really help push the ball over the goal line.
Yeah. And Clark, again, I want to emphasize, we're not whistling in the wind here. I mean, the times on Capitol Hill, I had companies come to me saying, let's repeal right to work laws. It's just certain things are not just going to happen. And one could pretend and get people to spend money on an elusive goal that will never going to happen. But that's not what we're talking about here. We really are talking about something which appears to be doable in the employment area if we just make the effort.
I think, Randy, it was going to be done this year, if not for the COVID pandemic. And so first of all, the reason I talked about it first is it was making the most legislative progress. In fact, it was scheduled for a Senate Judiciary hearing the first week that got canceled thanks to the pandemic. And I was very optimistic it was going to move. And I'll tell you how important people being involved is with a story of why I think it was going to move. Is there was a hospital in some of the worst parts of the city of Chicago that was sued. And they were sued due to the storage of opioid drugs. They used a thumbprint to access them in a safe. And they're always right on that fine line between being able to stay in business and being run out of business. And this suit might have been the tipping point. And so a sister, one of the nuns, called and said, I want to come talk about this. I actually had a busload of nuns coming down to talk in Springfield about that judiciary hearing. And I've done a lot of cool things in Springfield, but that thing, and the impact of that would have been one of the tops of my list. I think next spring, we'll have to start over with new numbers. It will be the same substantive language, but I think we can really get something moved and passed next spring.
Right, and the kind of improvements we're asking for are not gutting the law here. The law is going to stay in effect. It's really these areas that were poorly drafted, like no statute of limitations. How crazy is that? That there could be multiple violations, even if there's really only one. So, I mean, these kind of fixes are reasonable, and it's crazy that the law was written the way it was back in 2007. And again, we have an interest in trying to get those corrected.
$34 billion is real money to everybody except for the United States Congress. I mean, it's a shocking amount of money. For an assisted living facility to have to pay $2 million and nobody is damaged, it's kind of beyond the pale. And so I think everybody recognizes that we need to do something. But like I said, to do that, we need your help.
Right. So if you're interested in getting involved, and we hope you are, or just more information, you can email any of us, or I think we have a a poll here that we can bring up. So you've got a poll there on the right for those of you who can see the screen. And yes, I'd like to be an active participant in amending BIPA legislation and get regular updates. Or after all this, you need some time to think about it and go back to your boss. We understand that. Or no, we should have just taken, we should have not had no on there at all, Ada. We should have just had A and B. But the point is we hope you will check either A or B, and we can follow up with you and work with the Illinois Chamber and try and take some of these issues, some of these issues in hand and get this mess corrected. For those of you who can't see the poll, we're just on the phone. Of course, you can contact any of us, and certainly I'm at rkjohnson@seyfarth.com, but all our emails will be on the material when we send them out. But I'm at rkjohnson@seyfarth.com. So we hope you'll follow up. We plan on working with Ada, Clark, and Tom. We all plan on having another subsequent meeting to talk about the legislative strategy. And again, if we put our shoulder to the wheel here, we think we can get this accomplished, and it would be pretty cool for the business community as a whole.
Great. Thank you, Clark and Randy. Next, we're going to go to the question and answer part of the presentation. It looks like we do have some questions that have been submitted, so I'll kind of put those out to the group in order here. We have a few minutes left before our time ends. There's a question about are there any BIPA specifics for California when it comes to employment? In response to that, and then Tom, feel free to chime in. I think the California Consumer Protection Act, certainly there are some gray areas there that should be looked at in terms of when you're implementing compliance with the Illinois BIPA statute, but it remains a very gray area, and that's probably a presentation for another day. But Tom, I don't know if you have anything else you wanted to add in response to that question. And you're on mute, Tom.
I would look at the CCPA as well, which encompasses biometric data. It's a minefield of evolving regulation, so I would really try to keep tabs as to where it's at. There's differences in how notice is to be provided to employees as opposed to consumers, so there's distinctions there. But there's nothing like in the Illinois BIPA law that applies to California employees, if that's the question.
Another question we got was, is BIPA an Illinois statute, and how broad is this nationwide? So I'll chime in there that it's certainly an Illinois statute intended to govern Illinois conduct, but for any company that operates in Illinois, there is BIPA exposure. And on, for example, diversity jurisdiction grounds, you could file a lawsuit in any federal court bringing claims under Illinois law. And that's how we ended up with the Facebook case out in a California federal court. And what's notable about that, which I touched on earlier, is that you could be facing these types of state law claims in a jurisdiction that may not be as defendant friendly as the Seventh Circuit might be, or as even an Illinois court might be, in terms of taking into account, I think, the consumer focus of the statute. Tom, anything else you'd want to add on that one, or Clark or Randy? Okay, the next question. Our company is creating an app to passively collect activity, food intake, and eventually electronic health records, which will be analyzed with public domain data to provide personal recommendations for diet, physical activity, and then it looks like it cuts off. My guess is that the next part of it is, how much of BIPA is implicated in that. Tom, do you want to take that one?
Sure. I mean, and I apologize because it cuts off there, but really this goes towards our discussion about what data is being collected and whether or not it falls into one of those buckets that we discussed, biometric identifiers or biometric information. So, we're happy to kind of take a look at this more specific factual scenario if you want to contact us separately. But, that's part of that deeper dive that I think we always recommend be done prior to determining what kind of compliance is needed, if any.
Okay, and then the next question is that there are the questioner notes is 2 proposed pieces of federal legislation pending on COVID-19 and privacy, the COVID-19 Consumer Data Protection Act, the Public Health Emergency Privacy Act, and there's a question about any chance those bills may preempt BIPA.
One of the 2 Ada does. It's Chairman of the Commerce Committee, Roger Wicker's bill. It may pass the Senate. I don't think it has much of a future in the U.S. House. The other potential small area in the Fed for relief is Mitch McConnell's talked about the need for lawsuit protections for corporations as it relates to COVID and their COVID response. So maybe in the temperature scanning scenario. But once again, those things have only been introduced there, and there's not been any votes taken on there. And so I tend to still think that our best avenue for fixing that is right here in Springfield.
Yeah, I'd have to agree with Clark. The House, maybe the House will flip next year, but the House is not sympathetic to preemption of state laws, and even the House versions of the Wicker bill have had types of preemption language in there, but it's very unclear how it would apply. And the effort focused more on protecting companies from negligence claims than these sorts of things arising out of state statutes, even assuming that sort of protection or shield from liability gets through the House, which I think is going to still be a big question. So yeah, that stuff's up there, but absent an earthquake in the next election, I think that really our best bet is still trying to pursue these amendments to BIPA in terms of addressing the kind of issues that we've talked about today.
Thank you. The next question is, with the huge BIPA-related caseload related to cases where no injury has occurred by the plaintiff, why do you think an amendment hasn't been introduced to address this? And I think maybe, Clark, I'm happy to chime in too, but maybe you can talk about how these amendments are really trying to address this particular issue in the damages context, or I'm happy to chime in too if that's helpful.
Yeah, so actually last year, I think we saw the first introduction of really some type of reform, because it wasn't really an issue before that Rosenbach case. I mean, Tom talked about it. There were just a handful of suits until that happened, and then you saw an explosion. Then the business community, well, we have to clean this up. And the legislative proposals do try to address that lack of damages in certain ways. One, I think almost all of them, and the best way is to try to limit to either actual damages, which is the strictest way, or then to say $1,000 per identifier or per person as the various bills go.
Yeah, and Clark, as to why it hasn't been introduced already, well, I think that I mean it's sort of a catch-22. We've got to get there and make the case and show why this is a reasonable amendment. It just doesn't happen on its own.
The next question is there anticipated federal legislation in light of COVID and these issues? I think we touched on that a little bit already, but I just want to see, Randy, Clark, any other things you want to add on that?
No, Clark, jump in. I mean, there's a whole movement on the Hill. Some of it's bipartisan on addressing data privacy issues that have risen more out of the Facebook, Google context, and who owns the data. Can Facebook sell the data? The House Republicans, at least on judiciary, believe the data belongs to the consumer and Facebook shouldn't be selling it. And would there be some provision that could be slipped into a broader data privacy law that would address this? You know, perhaps that's sort of an 11th hour type strategy. And of course, there has been issues with regard to the use of sort of app-based interviewing techniques that gather up data on people. So it would have to be in the context, I think, of a broader data bill, and it slipped in at the 11th hour with leadership buy-in from both sides. But I just think that's unlikely.
The next question is, Tom, you might be particularly well suited to answer this one. I have some thoughts too, but maybe you can take it. Have you come across any cases dealing with the template argument, i.e. it's not a fingerprint, it's a sequence or template?
Not specifically. I know that that's something that defendants are planning to make, most likely at the summary judgment stage. You know, this argument that it can't be recreated, even if it was disclosed or breached, there's nothing you could do with it. It's a representation of X and O's and data points that would essentially be useless outside of that system. You know, which is particularly in light of like a timekeeping system. What are you going to use that for? So we expect that to be teed up soon at the summary judgment stage. And it also kind of harkens back to the discussion we had about biometric information and the broader definition, essentially a catch-all, where, you know, there's an argument to be made on the other side that, you know, it doesn't have to be, you know, just a fingerprint. It could arguably be something else derived from, you know, and there's different ways to read statute both ways on that front. So I expect there to be some resolution to that and that to be litigated here in the future.
And I would just add, you know, that's where we're seeing some of the expert activity as well, because you'll need an expert to testify precisely what's being collected, stored, and then whether it could be reconstructed. So that's an area where we expect, you know, expert consultant activity in these cases. Okay, next question. Is there any chance that any of the pending legislation will apply retroactively? So I would just chime in that, you know, I think the case law on whether you can do that is divided, but certainly if the amendment contains something to that effect, and I know Clark and Randy, if you want to talk to that issue, that could be something to aim for, because we know we have many, many people who are presently defending these cases.
Well, there's a whole ton of case law, and I'd have to go back and look at it in constitutional theory, that legislation, when does it become effective, and is it effective to a case that has been filed but has not yet been litigated? I mean, it's a complex area of the law, and typically, of course, things aren't retroactive, but there are ways to sort of look at that area between when does the cause of action arise, when is the case filed, and then when is it actually heard by the court. And in those three stages, there are some gray areas that hopefully we could slip in and move the quote unquote retroactive, I don't like to use that word, move the effective date as back as possible rather than calling it retroactive in those three windows. Clark, I don't know if you.
So I would love to see that. Unfortunately, I think it's going to be a difficult lift. And so there's a real tradition in Springfield that we don't put our thumbs on the judicial scales one way or the other. And if there's an active case, General Assembly tries not to weigh in on that active case. And I think we can get something done, but it's going to be difficult. And this might make it a little bit more difficult for us, unfortunately.
Next question, does an employer that uses a payroll vendor have a viable defense that it is not possessing or collecting, capturing, or obtaining any biometric information when all the biometric data goes straight to the vendor and the employer never has it? Tom, you want to take that one?
Sure, happy to. So I think that, you know, there's definitely an argument to be made, right? And again, this falls within one of the gray areas, but, you know, what constitutes collection? What constitutes capturing? Is the employer, by implementing this device on their grounds for their employees to use, is that collection, even though they're not actually collecting the data per se? You know, I think that I could see arguments both ways. I think I could see enterprising plaintiffs' lawyers saying, hey, you are collecting it. There would have been, you know, this never would have happened if you didn't put these machines on your property. You know, vice versa, I could see a kind of a statutory construction plain language argument where, hey, we're not receiving the data. So definitely an argument to be made and something to keep an eye on.
The next question is, as a vendor of technology that could be in scope, how much protection do we get Oh, and then I just lost the question. And I think the gist of it was, how much protection do we get from shifting responsibility to the end user of technology to obtain consent from the subjects? So I would just say, the more clarity we can have in these contracts between the vendors and the users of the technology, the better. I mean, this is an area where when these cases came in, the contracts were very rudimentary for the most part, and didn't identify who was responsible for what. So I think anything that can be done to clarify the responsibilities, but that won't, of course, as we're seeing too in the cases, as I've mentioned before, the plaintiff bar is filing the lawsuit, often a cookie cutter complaint, and then investigating later. So it's certainly not going to insulate you from lawsuits. It may be the sort of issue where you are identified as a defendant and you have to work it out behind the scenes in terms of who's responsible for what. Tom, I don't know if you have more to add to that.
No, I think you did it.
Okay, and the next question, I'm going to skip through since we're running a little lower on time. And I think this is a good one. Do you think there's any risk in developing a BIPA policy for something you feel emphatically is non-biometric, such as temperature only? Could this be read as an admission that temperature alone is biometric? Tom, what are your thoughts on that one?
It's a great question, and when we counsel with our clients, we try to draft these consent forms and policies in such a way to be very careful to not make that admission, to say and be very explicit about what the technology is doing to avoid any sort of admission. With that being said, I think that if there is an emphatic feeling that there is not biometrics being captured, then maybe there's other ways that you can go about compliance. But as far as admission goes, I think it really depends on how you draft it. A plaintiff could certainly argue that, but at the end of the day, it's capturing and collecting what it's capturing and collecting, which would be determined later on by the court or by the experts.
And I would just chime in that many of these compliance aspects are playing a significant role after the lawsuits are filed in any discussions about resolving the case. So if the plaintiff does get something wrong in the lawsuit, or you could leverage these types of policies to deter a lawsuit that's filed. So again, as Tom said, you simply make sure you're not conceding anything in them, but certainly the law should not discourage sort of extra consent and extra compliance with this type of thing, as long as you make sure you're not actually conceding the biometric piece in those materials. I think, I don't see much harm in more consent, more disclosure, considering the current litigation environment we are in with these cases. Okay, and I think we have reached the end of the questions that we can address here. There are a few additional questions that we'll answer separately offline. But thank you everyone for joining us today. This was an excellent question and answer session. We appreciate all of your questions and your time today. Thank you and have a good rest of the day.
And get involved.